Morning, counsel.
Mr. Chief Justice, and may it please the court, my name is Brad Benyon. I'm here representing Mr. Pariseau. This case will give this court a chance to look at remedies for my client under your case precedents of Blake. You'll recall that in the Blake case, this court set up a rule that after 30 days in a SDP case that's jury waived, absent extraordinary circumstances, a judge would have to issue an opinion. And this is because...
Can you tell me, do we know why the opinion did not issue within 30 days? Was it an oversight? Was it inadvertence? What was going on?
It's not on the record. But I think...
But is it the case that the first thing that is on the record is a letter from you or prior counsel?
Yes.
As sort of inquiring about it, which was, and then it was 3 days right after that, the opinion issued. Is that correct?
That's right.
So there's nothing between the end of the hearing and the letter from trial counsel?
Correct.
I thought that there was a 30-day period within which findings and rulings were going to be proposed. No?
That's true, and those came in...
30 days after the
First
hearing.
30 days after the hearing, everybody agrees that was just fine for the judge not to issue anything in that 30-day period.
Yes.
So it's the next 30-day period. It's actually 60 days.
Yes. So in this case, again, and I'm sure you're all aware, but my client has served his sentence. He served it well, no problems, and no problems while being civilly committed. In this case, my client feels that his best remedy is to be released. Because in this situation where he has served his sentence and he is being held committed through a process that can't commit him until it completes, he feels that his rights have been violated.
But and he says they were violated for 60 days, is that right?
Yeah.
Okay.
For how many days?
It's I haven't counted it, but it's the period from, and if you look in the
March
docket,
18th, be March 18th to July 30th?
It would be 30 days after the end of the hearing.
March 18th,
yes. So the decision came down in July.
Okay, so it's
April, May, June, July, almost 4 months.
almost 4 months, almost 4 months,
100
okay.
and something days.
If, as a practical matter, he said either it should be dismissed and he should be released,
Yes.
or a new trial granted, right?
Yeah, there is an alternative of a new trial. The problem with that is because Section 9 regularly grants new trials, these types of
He could do
cases where
that
new
anyway,
trials are
right.
granted are just folded into the new trial already, and that doesn't sit well with my client, obviously, because it puts no responsibility on the court, again, to issue a decision within the 30 days. In other words, a rule and a law is fine and good, but if there's no way, if there's no sting or enforcement procedure for the rule of the law, then it really does count for nothing. And that's what we're here to talk about. And so...
What about the suggestion that maybe, I mean, the court was pretty fractured in Blake.
It was.
What about the suggestion that the decision be made within 30 days, but findings and rulings can come thereafter? Name a period, 90 days, 120 days, only upon request, and then, I mean, there's
from a
certainly
person,
it happens in other situations,
It
like
does.
probate and family court.
it does, but this is a unique situation where, again, my client has served his sentence. He's being held, and to just receive a notice that he's been found sexually dangerous without any explanation as to why, and that decision can then come later, I think what my client's looking for is when he's being held civilly committed, he has a right to know then, at the time the judgment is made, why.
Mm-hmm. What was Blake itself ever meant? Does the record, because I understand you weren't trial counsel, but was the Blake decision ever mentioned at the end of the case, or when there was a discussion about we want 30 days to do I mean, did it ever come up
No,
as reflect?
no, because, again, it had been set up as the rule. I think it was presumed that all parties, including the judge, knew that that was the rule. And it's
Maybe
not-
we should reconsider the rule.
You know, my fear, of course, was that when further appellate review was granted, that that might be an idea that was floated. And let me talk a little bit about why I think that would be a terrible idea. The people that we're talking about under, who are civilly committed under this rule are prejudiced against. They're not liked. And to have a rule that requires a judge to issue a prompt decision on their civil commitment is a good one. It's fair, it's more than reasonable. But particularly when we're talking about this class of people who are being held for their crimes, which I think we can all agree don't sit well with any of us. The problem is that while a judge, while the mistake might be benign in these types of cases, there's a chance that the mistake might be intentional, that it could prejudice someone just to hold him. And
Could I just, but if this were a jury trial, he wouldn't have the information, he'd get the determination quickly, but no basis. So now you've got attention. You want a judge to make a determination. We've said that there should be findings so that, presumably, so you and we know what the basis of that is, but it's 30 days.
yes,
And you don't want an after-the-fact set of findings. Of course, everybody would prefer findings that then derive the result, right? That's the whole point of findings, not here's a justification. Let me get to the
That's
finding.
right.
All in 30 days. So it does, there's a problem there, isn't there? You want it all,
with
but can you
respect
do
to
it within the 30 days? The findings and the
that we want it all within a short time frame.
short time frame, I understand, but can you
Yeah.
have it all in 30 days?
These cases are unique for the reasons that I've already outlined again, and I can't stress this enough. Mr. Pariseau has served his sentence and is now being put through a process that is going to civilly commit him for life. And so while,
Well, unless he's, I mean, he does have the chance, quite apart from this, to bring a case every year.
it's not every year, but yeah, periodically he will bring a Section 9. But
So it isn't, I mean, it isn't as though by not deciding this within whatever, that signals he's going to be there for the rest of his life necessarily.
not necessarily, but again, that is still the wording of the judgment, and that is essentially what my client sees is, you are incarcerated for the term of your life, and while he understands that he can bring claims, it's that initial claim that is so important, the one that
The Section 14 one.
yes. And so, getting back to Justice Duffley, your comment, it is a lot to ask for in a short amount of time. And while a judge may be presumed to have to lay aside other work to focus on the SDP petition, I don't think it's a lot to ask. 30 days should be sufficient enough for a judge who has sat in the trial and has listened to all the evidence. As one who prepares briefs in a period of 40 days, who goes over these records and doesn't have the time to, I read the transcripts, but a judge who sits over, listens to the trial transcripts, gets access to the trial transcripts after he's heard the case, and then has the exhibit before him. I don't see that it's too burdensome, 30 days, to issue findings of facts and a decision.
Do you know that he or she is going to have the trial transcripts within that period of time?
No, not necessarily. But I think that they could be made available, or at least the recordings could be made available. But again, we're talking about a judge who's sitting in the trial, who sat at trial, and who took all this evidence. And I don't think 30 days, and the nice thing about the 30 days is that it remains fresh within the judge's mind, the facts that have been presented to him or her, so that judgment can be made.
And then the alternative of a determination followed by findings in that short period of time,
I'm sorry, say that again?
if finding followed by the determination followed by findings that you don't find acceptable, but seems to fit within that construct, make the decision while you're fresh in your mind, and then when you do have time, make the findings within a reasonable period of time afterwards.
Well, again, just speaking for my client, are you saying that that it's okay to issue a judgment first and then issue the findings? Is that what I understood? After some
For-
reasonable?
Yes, maybe
Again,
60 days later. Or,
Right, again, the problem here is he's being held on this process that has to determine whether he's sexually dangerous before it can really hold him for the period of his life. And to just have a judgment issued within 30 days is not satisfactory to him because, the court is charged with setting forth reasons. I mean,
But the jury wouldn't.
right.
the jury would not. There are trade-offs when you seek a jury trial, and there are trade-offs when you seek a jury
Right.
waive trial.
Right.
And when you seek a jury waive trial, according to Blake, one of the things that you can expect is that those reasons that are going to keep you incarcerated, and it is incarceration, are going to be outlined to you, and you have them within 30 days.
Why is there a need for this type of remedy as opposed to, we have a lot of deadlines, especially with regard to the criminal, first civil and now a criminal time standards, but violation of them does not result in dismissal. They have consequences on the conduct of judges, and the Raj and the trial court chief are there to help enforce them. But why must we impose this remedy?
I guess I'd answer that by saying what I've already said, and just maybe think about it in this way. He has served his sentence. So criminally, he has paid his debt to society. And now he's being put through a process that is going to determine whether he is civilly committed for the rest of his natural life. And the longer that period takes, and I understand that, there was, that Blake was, there were differing opinions, but at some point, that length of time is going to cause due process concerns. And we don't want to.
Is it your contention that more than 30 days is a due process issue?
No, not necessarily.
Okay,
Just
so,
enforcing the rule.
What we're looking at are, facts, but I think that the key language in Blake was those extraordinary circumstances, which were not put on the record. That's for the judge to do, to cite those, since it's.
okay, but here there's no contention that there was extraordinary
there's no
circumstances. So, one could argue that the rule at some level served you in that when you alerted the judge to it, 3 days later, the judge issues a decision. One can say that's in part because the SJC said there's a time limit and you've exceeded it. That we could say the rule, apart from the delay in informing the judge of the missed deadline, has had its effect.
I'm not sure that is necessarily a grand deterrent for these types of violations, simply because when you set out the 30-day period, if there's no sting or bite on the government who's bringing these claims, then in other words, Blake seems to put the importance on getting the court to act, whereas I think your question says that it's the attorney's obligation to act. And
No, but
that's not necessarily so.
One problem is that the consequence of what you're asking for will be borne not by the judge or the prosecutor, will be borne by the public, who will have somebody who is sexually dangerous on the street. It's a little bit hard to explain if a person who has been found to be sexually dangerous but too late commits another sexual crime. That's a problem for a court to basically say, yeah, he was released because although he was found sexually dangerous, the judge delayed too long.
It is, but in in a court, we're familiar with the idea of scales of justice, and you have to weigh those determinations. And what my client is putting forward is, his liberty interest is at stake, and process matters a great deal to him. In fact, process is really all he has in these types of situations. My time is up. If there
Your
are no
time is up. I
questions.
thank you very much. Yes, counsel.
Good morning, Your Honors. May it please the Court, Joseph Pariseau for the Commonwealth, and I would ask Chief Justice Ireland to consider revising the rule of Blake. I think the most expeditious
It was a
manner-
unanimous decision on that point, wasn't it?
Yes. I believe the most expeditious way to achieve any degree of justice is to abolish the requirement that a jury waive trial, a judge issue written findings. I see that in every criminal trial that I've ever tried in 26 years, I've never had a written decision. I've had many appeals.
This isn't a criminal trial.
It is not a criminal trial, but the Commonwealth bears the burden of proof beyond a reasonable doubt. It looks like a criminal trial in many different ways, and certainly the consequence to the respondent is tantamount to deprivation of liberty, albeit with the yearly possibility of having an opportunity for discharge.
You agree, though, this was a violation of the rule that we enunciated in Blake?
I cannot quarrel with that, Your Honor, because the Blake rule said written findings and verdict within 30 days. This is well beyond the 30 days. I would ask Your Honors, if you wish to peel the onion a little bit deeper, to consider on a case-by-case basis the facts of this case. As SDP cases go, the petition was filed only 11 months prior to the verdict, which is probably a record time for any trial in the Superior Court. As the court noted, when the judge was reminded politely by trial counsel, he replied within 3 days, which again bespeaks oversight. There's no formal recognition of that,
Right.
but to the trial judge's credit, as the appeals court noted, his written decision was well established and fully supported by the record.
What do you say about the fact that in the context of, the qualified examiner's reports, those prior steps, if they're not done within the 60-day period and filed, dismissal of the case, right?
Certainly, there is great precedent to say that if the Commonwealth fails to file a petition for trial in a timely fashion, if the Commonwealth fails to notify the treatment center of a finding of probable cause, the Commonwealth will be penalized with a dismissal
Of the case.
for failing to abide by the rule.
And the reason is that it is the holding of a respondent in this situation, or defendant, is a violation of his liberty rights because he's already done his sentence. So, I mean, we do have an issue there about it's, without a decision by the judge, you are still holding this person and depriving him of liberty without process, if you will.
2 points need to be made here, Your Honor, respectfully. Number one, now, albeit in this case, the respondent had in fact completed serving his sentence. Question, if the respondent had not completed his sentence, would the same remedies for dismissal under 123A apply if the Commonwealth failed to meet the deadlines?
I don't know.
I would say not. That's moot here for obvious reason, and I acknowledge that. But when we talk about rules, I think we always have to be cognizant of, as Brother Counsel pointed out, the scales of justice. In this particular case, the respondent, I misspeak, the respondent, although he instantly asks for dismissal or a new trial in the alternative, did not present, as Mr. Blake did not, any explanation of what he lost by
Well, no,
waiting.
Mr. Blake did, actually. He argued.
I believe,
Yes.
you're correct, I believe he
Had
did.
3 reasons why he.
Yes,
Yes.
and I believe the court, a minority of the court, or a plurality of the court, found otherwise. Getting back to my point here, the it would be beneficial to expedite the process and eliminate the requirement for written findings by simply imposing the 30-day deadline upon the judge to render a verdict. The record on appeal would be perfected. As the court knows from prior experience, SDP cases are extremely brief. It's virtually entirely expert testimony, most of which recites or repeats written reports that have been previously filed. So in terms of generating a record on appeal, it's almost instantaneous. Yes, you do need the trial transcript. But in these cases, these are not difficult cases to try. Likewise, they should not be difficult cases to make a decision. Now, certainly if a jury were to spend 30 days deliberating upon a case, they would raise some eyebrows. I suspect judges have more than one case on their mind when they deliberate upon these cases. But because these cases are so fact-specific from the point of view of competing expert opinions, as many as 5 in some cases, it would take time, I would concede, to do a comprehensive summary of the facts and to reduce it to writing. I think that asks too much of the judges.
It's clear that we've said that this must be done within 30 days, so 30 days runs. It's clear that the respondent can, file something with the court saying the 30 days has run, I have a right to a decision, right? That can be done.
That's certainly the
Filing
rule of
essentially a motion or alerting the court that the
Yes.
30 days has run and putting pressure on in that way. And if the opinion still isn't, or decision still isn't forthcoming, what does the defendant, can they file a writ of mandamus to compel it, or what? Is there some mechanism there?
I think there are several remedies available. One is number one, a motion to be released from temporary commitment, which I believe was mentioned possibly in the Blake decision. Of course, whenever the court discusses writs of mandamus, I think of delay. Already, this case is over 2 years old.
No, I'm just saying going forward.
But
so
I do believe that the opportunity to file either, a stay of the temporary commitment is certainly worthy of mention and perhaps meritorious. And that may be, in fact, the most effective remedy that a respondent can avail himself or herself of at the time. I truly believe that the rule needs to be reexamined. I believe I've made my points. Unless the court has further questions, I'll rest upon.
Just one other question. Is there any other civil case in which a judge can issue a ruling without findings of fact, conclusions of law?
Unfortunately, I've never practiced civil law, Your Honor. You stumped me on that one.
Rule 52 does require findings and rulings.
And yet, the rules of civil procedure are deemed not to pertain to SDP proceedings. We're in uncharted waters on a lot of this here, but I do agree that, and the Commonwealth should not be misunderstood here. Time is of the essence. I do not like to see people held without proper cause. But whereas here we have a strong factual basis, and what appears to be an oversight, an unintentional oversight, certainly this particular verdict should be affirmed. I would ask the court to impose any order prospectively.
All right, thank you, counsel.